Hey everyone and welcome. Today, we're going to solve a puzzle that's right at the heart of every single criminal case. Where does the trial actually happen? We're going to be your guide through the new rules of jurisdiction under the Bharatiya Nagarik Suraksha Sanhita, or the BNSS of 2023, which has replaced India's old criminal procedure code. So, let's dive right in.
So, let's kick things off with a super common scenario. Picture this. A theft goes down in Delhi, but the thief gets caught all the way over in Mumbai. Now, where does the trial take place? Should it be in Delhi, where the crime actually happened, or maybe Mumbai, where they found the suspect? This is the core question of jurisdiction, and trust me, by the end of this, you are going to have a crystal clear answer.
Here's how we're going to break it all down for you. First, we'll look at the one simple rule that actually covers most cases. Then, we'll see how the law gets flexible when crimes start crossing borders. We'll also dig into some major exceptions for serious offenses, and finally, we'll tie it all together to see what the big goal is behind all these rules.
Okay, so the law always likes to start with a simple foundational idea, and in this case, it's all about keeping it local. This core principle, it's laid out for us right in Section 197 of the BNSS.
First things first, let's lock in a key concept: local jurisdiction. The easiest way to think about it is like a court's home turf. It's the specific geographical area, like a city or a district, where that court has the official power to hear a case. This idea is absolutely central to everything we're about to discuss.
And here it is, the golden rule, right from Section 197. An offense has to be tried by the court in the local area where it was actually committed. It really is that simple. So if a theft happens in Udaipur, the case is heard by a court in Udaipur. Makes sense, right?
So you might be asking, why this rule? Well, it's not random at all. It's all about being practical. I mean, think about it. Where are you going to find the best evidence? Where are most of the witnesses going to be? Right where the crime happened. This rule just makes sure the trial is convenient for everyone and, most importantly, that it's efficient.
But the law is also smart. It's pragmatic. What happens if a trial ends up in the wrong place by mistake? Well, a really important case, Nasiruddin Khan versus the state of Bihar, established that this rule is about convenience, not a rigid, unbreakable law. So a conviction won't just get thrown out for being in the wrong jurisdiction unless, and this is the key part, it actually caused a real injustice to the person who is accused.
Of course, in the real world, crimes are often messy, right? They don't always happen neatly in one spot. They can start in one city and end in another, or even stretch across multiple state lines. So when that simple one place, one rule idea isn't enough, the law needs a more flexible set of tools. And that's where the exceptions come in.
This is where sections 198 all the way to 209 of the BNSS give us the answers we need. Think of these sections as a legal toolkit, specifically designed to handle the messy reality of these complicated multi-location crimes.
All right, let's dive into the main exceptions and see exactly how the law solves some of the most common jurisdictional puzzles you're likely to come across. Okay, Section 198 is basically the law's answer to, what if we're not sure? It gives one simple solution for three different tricky problems. First, what if it's genuinely unclear where the crime happened? Like in the case of State of MP versus KP Giara, where an embezzlement could have happened in either Bombay or Nagpur. Second, what if a crime starts in one place and finishes in another? And third, what about an offense that keeps happening across multiple areas? In all of these situations, the answer is the same. The trial can happen in any of those locations. Total flexibility.
Then we have Section 199. And this one brilliantly shows the link between cause and effect. So imagine a person is assaulted and injured in Agra. That's the criminal act. But tragically, they later die from those injuries in Ahmedabad. That's the consequence. Just like in cases such as Gujjing Singh versus the state of MP, the law says the trial can happen in either city, the place where the act happened or the place where the final result occurred.
Section 200 deals with what you could call the domino effect of crime. One crime often leads to another, right? For instance, a theft in one city might lead to somebody receiving those stolen goods in a totally different city. The law connects these two things, allowing the trial for receiving the stolen property to happen either where the original theft took place or where the goods were actually found.
Now for some really serious crimes, Section 201 gives us some special, very powerful rules. For something like dacoity, the trial can happen wherever an accused person is found, a principle we see in cases like Mohan Singh versus the state. For a kidnapping, it can be held anywhere the victim was taken or held captive. And for things like theft, it's either where the crime happened or where the stolen property was later found. You see, These rules are designed to make sure criminals can't just escape justice by crossing a district or state line.
All right, let's move on to some of the really unique situations. What happens when a crime is committed on a moving train? Or what about a crime committed by an Indian citizen on the other side of the planet? Yep, the law has answers for these too.
Section 203 is fascinating. It handles crimes that happen during the journey. Imagine a crime occurs on a train that's traveling from Delhi to Mumbai. On its way, it passes through Agra and Bhopal. Well, under this section, the case can be tried by a court in any district that the train passed through during that trip. It's just another amazing example of practical, flexible justice.
And what happens when a crime crosses international borders? Section 208 makes it incredibly clear. Indian law has a long reach. If an Indian citizen commits an offense anywhere in the world, they can be put on trial for it right here in India, specifically in the place where they are eventually found. Now, there is one very important check on this power. A trial like this can only happen with prior approval from the central government.
So, after going through the main rule and all these different exceptions, let's just zoom out for a second and ask the big question. What is the ultimate goal of this entire legal framework?
You know, when you put all these rules together, from that simple starting principle in Section 197 to all of its complicated exceptions, one clear picture starts to emerge. The whole system is built to balance three things: flexibility, uncertainty, and convenience. And the ultimate goal, the whole point, is to make sure that a minor technical detail about where a trial is held can never, ever be used to get in the way of the much larger goal of delivering justice.
So, that leaves us with one final thought to chew on. This whole system is built on flexibility, all in the name of achieving justice. But does that very flexibility, the fact that multiple courts could potentially hear a case, sometimes create its own brand of confusion and delays? It's a constant balancing act between being legally precise and being practically effective. Thanks so much for joining us.